Hello everyone, I'm George from Ireland. This is my English law channel. So I'm carrying on looking at voluntary manslaughter. Was talking about qualifying triggers when there's a very grave provocation of somebody which led to the defendant committing an act of heavy violence against the victim, which then leads to the victim's death. So there's an objective element to what a qualifying trigger is. So you have to expect the defendant to show the same degree of restraint as a person of that sex would, or that age would, and so forth, with an ordinary level of tolerance, bearing in mind the particular circumstances. There was a case where this was pertinent, which is R and Wilcox from 2016. I'm going to sneeze in a moment. So the Wilcox was convicted, then he appealed. It went up to the Court of Appeal. So they had to consider whether the appellant, who had a personality disorder, should get some special consideration. Is that a circumstance which the bench ought to take into account? Anyway, the Court of Appeal said that the trial judge was right to decline to allow this to be considered by the jury. Because the disorder, it lowered his ability to control himself. But the jury is not to think about that. They're to think about what an ordinary person would do in that situation. Being a man, being a woman, that's relevant of whatever age. I'm not sure how age makes you more self-restrained or less self-restrained. Being hetero, being homo, I'm not sure why that is considered relevant, but they did put that in there. Physical appearance, is it because they've insulted your physical appearance, being too skinny, being too obese, being too tall, too short, having severe acne, only one eye? I'm not sure. You might be insulted about that, and maybe that's what causes you to lose it. Past events and experience. Anyway, so the defendant is not allowed to use any outside aspect of his character, such as he's got a low frustration tolerance, or he's under the influence of alcohol or drugs, anything like that. In Asmalash 2013, in that case, somebody said, yes, but I was intoxicated at the time. Well, that's no defense. If you self-induced intoxication will not render you less liable to a conviction. So people are expected to exercise the same degree of self-restraint as an ordinary person would in those circumstances. There is a defence of diminished responsibility, which you could look at later, but that's separate to provocation and this temporary loss of self-control. Otherwise, people who have a more explosive temper would get off more easily. So let's look at the evidence and procedure which are relevant to this. The Coroners and Justice Act 2009 describes what is to be done in a case of a voluntary manslaughter. So, and here is a quotation. On a charge of murder, if sufficient evidence is adduced to raise the issue with respect to the defence under subsection 1, the jury must assume that the defence is satisfied unless the prosecution proves beyond reasonable doubt that it is not. For the purposes of subsection 5, sufficient evidence is adduced to raise an issue with respect to the defence if the evidence is adduced on which, in the opinion of the trial judge, a jury properly directed could reasonably conclude that the defence might apply. That's the end of the quotation. So therefore, the burden of disproof is with the prosecution. So the defence say, well, provocation, yeah, that's why this killing was carried out. Therefore, it's got to be voluntary manslaughter. But it's up to the defence to disprove that. If the defence can't it's up to the prosecution to disprove that. If the prosecution can't disprove it, the defence will operate. The person will be convicted, but only voluntary manslaughter. It can't go up to murder. So anyway, the judge must decide whether the evidence cited by the defendant is capable of turning it into voluntary manslaughter. So that doesn't mean the judge decides that it does turn it into voluntary manslaughter, only that it could turn it voluntary manslaughter. The jury can then say, yes, okay, this is voluntary manslaughter, or the jury could say, no, it's not voluntary manslaughter, it's murder. So the judge would not allow the evidence to the jury to consider any evidence, such as the person said, well, I lost self-control because I've been drinking, or because I was envious, I believed my girlfriend had been doing with somebody else, or because I was annoyed by this person just moaning all the time, or there was an infant wailing and I lost it. Right? Okay. However, the defences that could operate is if the victim threatened to harm the defendant or to do physical harm to another person, such as a child in particular, or things like that. Okay. Anything would be considered to be exceedingly serious. So anyway, there's a Court of Appeal decision in R and Dawes, or R and Hatter, or in R and Bowyer. So anyway, there is not this is up to this is a matter of not a matter of the judge's judgment. It's but a matter of whether the judgment is correct or not. So Martin 2017, the Court of Appeal says it's going to be reluctant to overturn the judge's decision because he or she has heard it firsthand. So if in the opinion of the judge, remember those are the words used in the relevant statute, if in the opinion of the judge, judges are individuals, one judge will say, yeah, it can be put to a jury, another will not. So we'd rather have consistency here, but the Court of Appeal doesn't want to always be overruling judges. So we could look now at diminished responsibility. So this is as set out in the Homicide Act 1957 in section 2 thereof. So the aim here is to provide discretion in sentencing when it comes to murder if there is major mitigation. Because remember, until 1965, people could be hanged in the United Kingdom for certain categories of murder: premeditated murder, murder in furtherance of a robbery, and so forth. So anyway, the Coroners and Justice Act 2009 reformulated this in section 52. The main changes here said that there are certain types of mental disorder which would provide a valid defence. Anyway, it is not a major change from the Homicide Act 1957, but here the standard of proof is the civil standard, as in the balance of probabilities, not the usual criminal standard, which is beyond all reasonable doubt. So the Coroners and Justice Act 2009, section 2.1 says the following: if a person, defendant, who kills or is party to the killing of another is not to be convicted of murder if the defendant was suffering from an abnormality of mental functioning, and this arose from a recognized medical condition, substantially impaired the defendant's ability to do one or more of the things mentioned in section 1A, and provides an explanation for the defendant's acts and omissions in doing or being a party to the killing. That's the end of the quotation. I'm about to come to section 1A. This is the list of the things which the defendant must be impaired from doing or completely unable to do. So if the defendant is unable to do one of them or more than one of them, then the defense will operate. Then this will not be murder. It'll be voluntary manslaughter on the basis of diminished responsibility. Here's the list 1A. Those things are to understand the nature of the defendant's conduct, to form a rational judgment, and to exercise self-control. That's the end of the quotation. So the three things are to understand the nature of the defendant's conduct, as in one's own conduct, being the defendant, or to form a rational judgment, or to exercise self-control. So if you can't do one of them, two of them, or even all three, then the defense will stand. Or if you're substantially impaired from doing them, you can partly do them, but only to a limited extent. So let's consider the derangement of mind arising from a recognized mental condition. You can't just say, oh, I'm mental or whatever. No. There must be psychiatrists who said this is for real. So if psychiatrists certify that the person suffers from some abnormal functioning of the mind, but it's got to be a serious deviation from the norm. It can't be something trifling. But anyway, so if you kill someone because of your mind malfunctioning, might make you misunderstand the victim's words or actions and consider something which is unobjectionable to be foully offensive, to misperceive dangers where none exist, or to hugely overestimate the level of jeopardy that the one is in. You could be killing someone because you've got auditory hallucinations, schizophrenics get this, thought projection or whatever, God told me to do it, or things like that, or I was possessed by a demon. Because at some of their abnormal mental state, they're unable to exercise an ordinary degree of self-control. Okay, so recognize mental conditions. Now, under the previous law, They didn't need to show that it came from a recognised psychiatric condition, so long as it was something inherent. So this showed some flexibility. Which is that desirable or not? Well, that's rather debatable. Anyway, the defendant can no longer cite this defence saying he was a very envious person, or he was unable to control himself because he was so impatient, having suffered some malady or something like that, or his daughter was being very ill and that had just made him very irritable. No. So the recognised medical conditions are usually those ones listed in the International Classification Diseases, or indeed the Diagnostic and Statistical Manual. The Diagnostic and Statistical Manual being prepared by the American Psychiatric Association, but it's a widely cited reference text all around the globe. So anyway, some of the mental conditions which would ground the defence would be an arrested or retarded mental development, as in this person being seriously subnormal, an adult who is in effect not an adult, having the mind of a small child, depression as per Gittins, 1984, could be the person's got bipolar disorder, and that was shown in the case of Inglis, 2010, paranoid schizophrenia, that was Sutcliffe in 1981, Peter Sutcliffe, the Yorkshire Ripper, who just died recently, who murdered several women in Yorkshire in the late 1970s. It could be because the person has sustained brain damage. It could be psychopathy, as per Byrne, 1960, or indeed paranoid personality disorder. Martin Anthony, 2001. He's that muttering farmer who was highly eccentric, who killed a burglar in 2001. It could be because the person was suffering from postpartum depression, such as in Reynolds, 1988. Now, expert witnesses will be called to testify here because sometimes the condition is disputable. In Brennan 2014, there was a case of this because the medical evidence which was used to cite the defence of definitive responsibility was put to the jury by a medical expert, and the prosecution didn't contradict the evidence with their own medical expert. And so if the prosecution find this unhelpful, the evidence cited from the defence, and they usually do, they can find their own medical expert to try to disprove the testimony which is marshalled by the defence. Anyway, so the battered woman syndrome in Ahluwalia, that was cited, but okay, that defence worked, and that was a legal breakthrough. There was Hobson, 1988. And there was a premenstrual syndrome. If you look at Smith, Sandy, 1982, we have to give a Christian name Sandy because there's so many Smiths. Okay, so the judge has to decide whether such evidence can be put to the jury or not. In Osborne, 2010, the Court of Appeal decided that attention deficit hyperactivity disorder wasn't a sufficient reason. The person being convicted of murder and then appealed on the grounds of diminished responsibility. The ADHD made him particularly liable to kill people, but the Court of Appeal said that's nonsense. The appeal is denied. Okay, so let's come on to intoxication in relation to such cases. Now, the law previously drew a distinction between getting blind drunk one night and being just a hopeless alcoholic every day. So this is still there. So intoxication isn't a medical condition as per Fenton, 1975. So therefore that's not a defence. But in Dowd, 2012, the Court of Appeal said that if you get yourself really drunk, well, that's no defence here. Now, having an abnormal mind might not be the only reason for killing somebody. Might be whatever reason plus the abnormality. Anyway, so, but a person who kills partly because he's drunk and partly because he's got a recognised mental condition could have a defence, not automatically has a defence. So look at the case of Deichmann in 2003, and this went the earlier case of Egan, 1994. So the defendant, who was a schizophrenic, couldn't show that schizophrenia was the reason for him killing. He was very drunk at the time. So just simply because a person is schizophrenic does not automatically mean that defence is going to work. There has to be another reason. Anyway, So if the defendant is a hopeless drunkard, well, that's quite different, because these people, they've made themselves mentally ill through alcohol abuse. They have no control over that. So someone who drinks occasionally is not an alcoholic who gets drunk once a week. But if you get drunk pretty much every day, drinking in the morning, then that is dipsomania. So chronic alcoholism is a medical condition, as any doctor will tell you. So they have less ability to control themselves. The mind is befogged and so on. They're likely to just erupt in rage and things like that. So they cannot form proper judgments. So anyway, so Kay tried to use this defense, but it didn't work. There have been other cases like Wood 2009 or Stewart 2009, where this chronic alcoholism had been cited as a defense. So Wood, in this case, there was a guy who was a tramp who was an alcoholic, and whilst very much under the influence of alcohol, he killed someone whom he claimed had hit on him in a homosexualist manner. So the judge gave the wrong impression to the jury, saying that the defendant getting drunk had to be totally involuntary to count as some sort of internal disorder. And for that to operate as a defence. Well, he was convicted. Now, then Wood appealed, and the appellant said this was a misdirection, as in the judge had erred in law. He'd given the jury the wrong advice. So it went to the Queen's Bench Division, and they said that the trial judge was mistaken. Unless every drink consumed that day by the appellant was involuntary, his alcohol dependency syndrome was to be disregarded. That's what the judge had said. Okay, so we're looking at whether intoxication can provide some sort of defense, as in make it voluntary manslaughter rather than murder. So it's got to be the reason for the killing. So it can't be, yes, you're an alcoholic or whatever, but that's not why you killed. You killed for another reason. And doesn't mean killing personally necessarily or on your own, might be as part of a group. So it must be critical to the reason why the slaying took place, so that he would do things which were very injudicious. He couldn't fully comprehend what was going on. They wouldn't be cognizant of the situation. They wouldn't realize what they're doing is very dangerous or something like that, because he had rather less self-restraint than the man on the street. So a psychopath is not going to be able to use this defense, because they wouldn't have proper abilities to control themselves. They don't have the ordinary cognitive function. So the Coroners and Justice Act 2009 says that the reason will be provided, and here's a quotation, if it causes or is a significant contributory factor to the killing, causing defendant to carry out that conduct. That's the end of the quotation. So does that explicate why the killing took place? Now that's up to the jury to decide. Consider, is this why the killing took place or not? The jury will decide. We've got to see whether it will even be put to them. And the judge might say, no, it's not even worth considering, or it is worth considering. The judge won't decide whether that's why the killing took place. The jury will decide. But there has to be at least a prima facie case that is why the killing occurred. So the thing is, a murder is often multifactorial. It could be that this person was suffering some serious depression, the person was blind drunk, or the person was a severe dipsomaniac at the best of times, and so on. Okay, we've got to see that this alcohol abuse had seriously impaired the person's faculties. So the defense only works if alcoholism or some other psychiatric condition substantially hampered the defendant's ability to do some of the things mentioned in section 52.1a. So what is substantially? Well, that obviously that means seriously. It can't be a small amount. It has to be to a very extensive extent. Anyway, in Goals 2014, the Court of Appeal had to consider this very issue, and they went with the interpretation that the defendant's mental abnormality had to be a major factor in causing the killing, meaning that he didn't have the usual capacity to control himself. And now, does his impairment cause him to do this? How is the impairment severe enough to provide an explanation for him being unable to restrain himself? That's for the jury to decide again. So it's not doctors decide, it's doctors provide advice, they argue this way or that way, and then the jury have to make up their mind of which doctor they go with, assuming that a medical expert is cited by both sides. So anyway, there was an appeal, and the Supreme Court, sorry, they approved this judgment, and they denied Gold's appeal. They said that for diminished responsibility, and this is what the Supreme Court said, substantially impaired means something, whilst short of total impairment, nevertheless is significant and appreciable. That's the end of the quotation. So Gold could have some degree of self-restraint, but so long as it's far less self-restraint than average, well, that defence could operate. In this case, his self-restraint, his ability to restrain himself, was significant. Therefore, the impairment was not enough to ground the defence. Anyway, so that's enough for on voluntary manslaughter for the moment. Toodaloo.